Now we go to the interview session. I would like you to tell us why you think you are suitable for the position of a judge of the Court of Appeal. What special skills, knowledge, and values you're going to hand to the Court of Appeal. In that, I hope your vision, the vision you have, and your core values will come out of that discussion. You have 5 minutes.
Thank you, Madam CJ. Perhaps I could start by introducing myself, and then I will go to answering your question. As you have noted from my application, my name is Daniel Ochieng Ogola. I'm a practicing advocate of the High Court for almost the last 3 decades. I was admitted to the bar on the 5th of June, 1996. And mid this year, I'll be celebrating my 30th year of practice. Commissioners and Madam CJ, my career started in 1995 in the law firm of Kaplan and Stratton, where I was privileged to be trained and mentored by leading lawyers in this country. I was an intern there for 1 year, and subsequently I was employed as a legal assistant, researcher. In brief, during that time, I was able to acquire skills of research, working with various people of all walks of life. I'm a team player, and one of the things I learned there is to look for the law and know where it's found and apply it to the current or to the particular circumstances of each case. From 1998 to date, I have been in private practice running a law firm called Ogola, Ochieng and Company Advocates, based here in Nairobi, for the last 27 years. In the course of my practice, I've practiced in various courts, from the Magistrates Court to the High Court to the Court of Appeal, and my major especially is in the area of land law and commercial practice. In the course of my long career, mentorship has played an active role. I have mentored several advocates, land registrars, bank executives, practicing advocates, and mentorship is something very core and close to my heart. In my practice in land law, I have also developed jurisprudence, especially in the area of professional undertakings by lawyers. And this is one area where I have shown or developed legal knowledge in the area of professional undertakings and duty of lawyers as officers of the court. In my long career, I have worked for both private citizens, banks, institutions, parastatals, quasi-government organizations, and I bring to this court values of humility, honesty, reliability, professionalism in what I do. I have developed adversary skills to my clients, and above all, I bring in the values of Chapter 6 and Article 232 required of a state officer. My lady, In the last 5 years, I have been privileged to chair the Competition Tribunal since September 2020 to September 2025. My experience as the tribunal has exposed me to the workings of the judiciary. I have interacted with very many judiciary programs. I'm alive to the mission and vision of the judiciary, the blueprint on STAJ. I have also been privileged to be trained by the judiciary, both locally and regionally. I have attended Judges Conference in Malawi and Zambia, and I believe I have the competence, skill, analytical skills to apply law into practice. I am a team player. I am a candidate of measured temperament. The tribunal has also exposed me to collegiality and working with colleagues. In the tribunal, we sat as an appeals court, hearing and determining matters which were brought before the tribunal against the decision of the regulator. I'm very, very versed with the appeal process, and I believe this makes me a suitable candidate for this position. Above all, I meet all the constitutional thresholds and requirements for this high office, and it is my desire to progress my career to this high office, hence my application.
Thank you. Commissioner Mwansa will lead us in the next set of questions.
Thank you, Chief Justice. Counsel, good morning.
Good morning, Commissioner.
Famous American poet Maya Angelou says that courage is the most important of all the virtues, because without it, you can't practice any other virtue consistently. Now, based on that reflection, can you tell us the key aspects of judicial courage that is expected of a judge?
Thank you, Commissioner. That question of judicial courage goes to the core principle required of judges: to be independent and to make decisions independently without any direction from any party. This is one of the cardinal principles of judicial or conduct required of judges, and it is one of the principles in the Bangalore principles of conduct required of judges.
So that is one. If you can just say three key aspects of judicial courage.
Judicial courage is, first of all, to uphold constitutionalism, to
Yes.
interpret the Constitution,
Yes.
and apply it as a living document to the lifestyles of Kenyans. Judicial courage would also include making decisions irrespective of whether, or rather not looking on your shoulders to try and understand or to be directed by anyone. So I think this would form what judicial courage is.
Would resisting popularity also be an aspect of judicial courage?
Thank you, Commissioner. I think the word would be to apply the law and uphold the Constitution, whether it makes you unpopular or not. I think these are the cardinal principles of judicial courage.
Thank you. Now, you've read the decision of the Supreme Court in the case of Fatuma, Faraj versus Ruth Faith Mwawasi. You've come across or interacted with that decision?
Commissioner, I have not had a chance to look at this decision.
Oh, it's a fairly recent decision that affirmed that children who are born out of wedlock to a Muslim father have an equal right to inherit from his estate.
Yes, Commissioner, I didn't have the citation, but I'm aware about the facts of this case.
You're aware about that?
Yes.
What is the key holding in that case?
The key holding is, in this case, is that the best interests of a child have to be borne in mind and considered at all times, irrespective of whether the child was born out of parents who are legally married or who are born out of wedlock. The key thing here being the best interests of the child.
Okay, that was one of the principles.
Yes.
Now, suppose this child who was involved was an adult child, so that Article 53 was not engaged. Would that have changed the decision?
I think it would have, because in the definition of in the Constitution, a child means someone below the age of 18 years.
Yes, a minor.
A minor.
But you know, I was just thinking about it when I was reading this decision, that suppose this was not a child who was a minor, and maybe somebody my age or your age was claiming for this. Would you think the same principles will apply, and perhaps the Supreme Court will have maybe arrived at a different conclusion?
I think that is a question of fact, but minors have a higher standing in the law and in the Constitution.
No. I just want to see how you apply the law, because sometimes a case can present itself in many facets, and I thought, you know, what would happen. So I want to hear your mind, what your thinking is, if number one, this child, or quote unquote, who was claiming, is somebody who was of the age of majority. It's not a minor. And then number two, I also noted that this case did not begin in the Kadhi's court. It actually came through the High Court. It was filed in the High Court. If the case was filed in the Kadhi's court, would that again have changed the outcome?
Yes, I think it would have.
Those two, just answer to those two. The
yes.
First one is whether it's not a minor, and number two, whether it had commenced in the Kadhi's court.
First and foremost, I note that the parties in this case are Muslims, and therefore Sharia law or Islamic law would be what would be applicable to them. Coming to the second issue of...
But if Islamic law was applicable to them, this child born out of wedlock would not be entitled to inheritance.
I think the Constitution takes supremacy over all laws.
And what clause is that?
I think it is Article 165. Where the Constitution, the decisions of the Supreme Court binds.
165 or 163?
163, sorry.
Okay. Then lastly, I want to read for you an article of the Constitution that was applied by the Supreme Court. It's Article 24.4. which states that the provisions of this chapter on equality shall be qualified to the extent strictly necessary for the application of Muslim law before the Qadhi's court to persons who profess the Muslim religions in matters relating to personal status, marriage, divorce, and inheritance. Hence my first question. Are you on that article?
You're reading Article
24.4.
24.4.
Yes. The provisions of this chapter on equality shall be qualified to the extent strictly necessary for the application of Muslim law before the Qadhi's court to persons who profess the Muslim faith, Muslim religion in matters relating to personal status, marriage, divorce, and inheritance. You're there?
Yes, I'm there.
Now, if you look at 24.4, one of the factors to consider is the matter starts at the Qadhi's court.
Yes.
Okay. Then the second is that there is an interesting framing of phraseology that says that equality shall be qualified to the extent strictly necessary. What would be understanding of that?
I think what this provision states is
Or rather, what is the constitutional principle that you get out of that?
it's like a limitation of rights.
Yes.
To
And
apply
balanced against what?
to people, to persons professing the Muslim faith,
Okay.
and in matters before the Qadhi's court.
Okay. All right. Thank you, CJ.
Honorable CJ and Wakili, welcome.
Thank you, Commissioner.
Judges are part of the society, and many a times you must have heard people saying judges do not ascend to the heaven in the evening and come back in the morning, meaning that they are part and parcel of the community. Therefore, whatever happens around the community concerns, or it comes to the attention of judges. Now, being a practitioner of many years standing and having expressed interest in joining judiciary, you must have been interested in whatever has been happening, not only within the Kenyan space, but world over. That's it, Mr. Daniel? Okay. One of the events which took place recently, not within this country, elsewhere, related to the arrest of a sitting president. And naturally, as a lawyer who intends to join the Court of Appeal, you must have spent some little time to think about the happenings in that place vis-a-vis the position in Kenya. Now, do you think that the Constitution of Kenya allows a scenario where a sitting president can be arrested under international law?
Thank you, Commissioner. Is it a sitting president or a sitting CJ? What is the question? Sorry, please clarify.
President. A sitting president.
Thank you, Commissioner. This is a question of fact, depending on the circumstances, but in Kenya, the president has immunity under the Constitution, and there are specific ways or methodologies of removing a president. as laid out in the Constitution. So, by virtue of a president being arrested outside the provisions of the Constitution, it would appear to me to be unconstitutional if due process is not followed in the arrest. That would be my take for this question.
In this case, due process will mean?
Due process means following the laid out provisions of the Constitution. Otherwise, whatever actions would be outside the Constitution, hence unconstitutional.
Okay, you may need to have a look at Article 143 of the Constitution. It will give you the appropriate guideline. Okay, next, because we'll be sitting in the Court of Appeal, if successful, and I pray that you succeed to join the courts, you'll be interacting with the Bill of Rights almost on a daily basis. That will be one of the key things you should be undertaking in that court. Now, I just want to give you a brief scenario. Just a brief scenario. Two people of the same sex. Two people of the same sex appear before marriage registrar intending to marry. And the officer refuses to officiate the ceremony, citing a certain provision of the Constitution to the effect that marriages in Kenya must be between persons of the opposite sex. Now, these two people are offended by that decision, and they file a petition seeking to declare or seeking a declaration that they were discriminated against under Article 27 of the Constitution. Have you understood the scenario? Have you gotten it right?
Yes, I have.
Oh, thank you. Now, what is your likely decision in that? On one hand, they are saying our rights have been infringed because we ought not to be discriminated against. On the other side, the officer says Article 45 does not allow. What will your take be?
Thank you, Commissioner. I believe under the Constitution, marriage is for persons of the opposite sex, yes, and not persons of the same sex. I've not had an opportunity to read any judgment coming from this jurisdiction where the court has upheld marriage between same sex.
But they have now appeared before you. They are saying Article 27 guards us against discrimination. We ought not to be discriminated on that.
It is true. The right against discrimination is there in the Constitution, yes, but it is not absolute. And in this case, restrictions or the constitutional provisions will be weighed. And also something important here would be public interest to approve such marriages. So I believe if I was sitting as a judge,
yes,
I would not grant them the rights.
Okay.
The right to marry persons of the same sex is not one of those rights that cannot be derogated.
Okay. In other words, the marriage, same-sex marriage, is specifically not allowed by the Constitution. The Constitution is clear in its text that these type of marriages are not allowed in Kenya. So you cannot now come under the guise of discrimination and try to go around that provision.
That is the position, Commissioner.
Thank you so much, and I wish you well.
Thank you.
Good morning, Mr. Ogola.
Good morning, Madam Attorney General.
Yes. I don't know whether you'll agree with me that our Constitution 2010 has expanded the landscape of the terrain of judicial review in definition and remedies.
That is correct, Commissioner.
Now, we have instances where a matter is admitted in court under those two, under Article 22 and 258 as matters in the public interest. Article 22, 2C, and 258, 2C, enforcement of Bill of Rights and enforcement of the Constitution. A matter is admitted as in the public interest, and in some instances, some conservatory orders are given. A practice is evolving where applicants in those matters sometimes approach the court to be given time to negotiate out of court or to withdraw those matters. And sometimes the courts have yielded. My question is, from an appellate perspective, do you consider constitutional public interest litigation to be inherently non-negotiable? Or are there limited circumstances under which negotiated outcomes, maybe such as consent frameworks, may be permissible without undermining constitutional supremacy? And what safeguards would you require to prevent erosion of public interest?
Thank you for that question. In my understanding of the question, there are cases when the court would not allow parties to negotiate. And these may be cases involving such as sexual offenses or offenses against the child. But in other disputes, like commercial disputes or any other disputes, the court may give leeway to the parties to negotiate.
The foundation of the case is in the public interest.
In public interest cases, the court will ordinarily look at what is for the public good and weigh the public good against such interests. So the court will give superiority to what is in the public interest in such cases.
Are there instances where courts can allow negotiation?
I am looking at a situation where a party comes before the court and says public interest or public rights or rights of anybody is likely to be threatened or is likely to be infringed. And maybe I'm looking at an environmental case. And the regulator, for example, or a county government comes before the court and says, we've realized we need to do public participation before we implement this law. So in such cases, the court can give room to the parties to negotiate with a view of meeting expectations of public interest.
Okay, and second question, what judicial innovations or evidentiary indicators can appellate courts employ to interrogate and unmask private or commercial interests presented under the guise of public interest without prematurely striking out meritorious claims?
Thank you, Madam AG. That will be a question of fact, again, looking at the pleadings before a judge. And it is always critical for judges to look at pleadings and weed out such pleadings that have been framed or coined as public interest litigation, so that what is key in those matters is to evaluate what is in the best interests of the public against, for example, private claims framed as public interest litigation.
And in this regard, what would you how would you define public interest?
Public interest essentially means what is in the public good or beneficial to the public, as opposed to, for example, personal or private rights.
Okay, finally, I note that you have a Master's of Law in Environmental Law from University of Nairobi.
Yes, Commissioner.
Can arbitration properly extend into traditionally public law domains such as environmental law, land governance, or public procurement without undermining constitutional accountability? And what principles should guide arbitral tribunals and courts in such cases?
My lady, could you please repeat the question?
Can arbitration properly extend into traditionally public law domains such as environmental law, land governance, or public procurement without undermining constitutional accountability? I get it that you know what arbitration is and the issue of party autonomy?
Yes, my lady.
Yes.
Arbitration is a voluntary process where parties have chosen that their disputes be settled in a certain way in a contract. I would strictly say that in public law, this would not work, unless we are looking as something like under Section 35 of the Arbitration Act, where a matter is of general public importance. And a matter like that is brought before the court for determination. And in such cases, then the courts may intervene.
Thank you, Honorable Chief Justice. Mr. Ogola, it is presumed that when you get to this position of a judge of the Court of Appeal, you're very well versed in terms of the substantive law as well as the procedure. Basically, what I'm trying to say is that the wealth of experience that you've gathered over a period of time comes in extremely handy, because you'll face a myriad of varied cases that will be presented before the court. In the course of these interviews, we've talked a lot about the law of succession, and I would want us to still interrogate some sections or some provisions of this law. Now, we've also heard that a woman is entitled to a life interest upon the demise of a spouse. What happens when the man dies and they had no children and he leaves behind his wife? What is the entitlement of this lady as regards her deceased husband's property?
Thank you, Commissioner. It is true, as you put it correctly in the question, that where two parties are married without children, then in the event of the man dying, the lady is entitled to the life interest of the property. However, in cases where there are no children, it would ordinarily follow that the half interest of the spouse would ordinarily go to the lady.
Half?
The full interest.
Let's be clear about what we are talking about. So the man has died, the wife has survived him. We've talked about a wife being entitled to a life interest. But in the event that there are no children, what is our entitlement?
I believe the situation would not change
The situation will not change.
if there are no children.
So the situation will change or will not change?
It will change because she will be the sole owner or inheritor of the man's estate.
So you think because the children are missing, she will take, it will not now be a question of a life interest, but she will inherit her husband's property.
That is the position, Commissioner.
You may need to check on the law of succession because that it doesn't say that. If a son or a daughter dies and they die without having married, how does this property devolve?
I think in an intestate situation,
Yes, intestate, sorry.
yes, the property will devolve according to, under the Succession Act, to the next of kin. In this case, if they have parents, then the parents have priority.
So we have a mother, we have a father. Who takes priority over the other?
I think both parents have the same rights in such a case.
Equal shares.
I will have to check on that, Commissioner.
It is important that you check on that because we are saying we are looking for judges where they come, they go, they hear a matter in court, they come out of court, they are conferencing, they are providing the way forward in terms of generation of the draft. Now, in the recent past, we've seen children actually going to court demanding to be given part of their parents' property or the entire property that the parents may be owning. Have you seen that?
I have seen that, my lady.
Yes. Any case that comes to mind that has been taken to our courts and a decision made as regards this aspect?
My lady, if I may recollect, there was a decision by Justice Mchelule where he held that any child who's above 18 years old, there is no parental responsibility by the parent to take care of such a child once he attains the age of 18 years.
That may be the question of parental responsibility, but I'm asking you about children going to court and saying we want a share of their parents' property. It's not now a question of responsibility, but
yes,
it's like...
actually the same case dealt with that issue, and I presume from your question that the parents are alive as at the time the children are making this application. And I think Justice Mchelule in that case held that children cannot file applications against their parents seeking to be given portions of their parents' property during their lifetime.
You're saying applications cannot file applications?
They can't file, but as to whether it will succeed is another issue.
Is it an application, or is it a petition, is it a plaint? We are lawyers and we must be very careful.
Sorry, my lady,
about the terminologies.
It is a petition.
Application?
Petition.
It is a petition. Now, are you also aware that Justice Sila Munyao made a decision along similar lines, saying that children cannot successfully file a claim wanting to inherit property from their parents when the parents are still alive?
The decision I recall reading is the one for Justice Mchelule.
Okay. But supposing, like in the one that was the case that was determined by Justice Sila Munyao, the land was inherited land. The parents inherited from their parents, and hence a child is saying, I'm entitled to this land because it is ancestral land.
I think when it comes to inheritance during the lifetime of a parent, the children get their rights on demise of the parents. And I think it would be wrong for children to claim they can be entitled to inheritance during the lifetime of their parents. That would be my take for that question.
All right. And then Justice Hila Munyao sits in the Environment and Land Court. And he made this decision saying that as a child, you are not entitled to inherit property from your parents, or you have no right really to go to court and say you want to inherit from your parents during their lifetime. Is it strange, is it odd that Justice Hila Munyao sits in an Environment and Land Court, and here he seems to be making a determination in a matter that is a succession matter?
My lady, I know the Supreme Court has made a decision that judges of specialized courts only have jurisdictions in matters relating to the specialized court, unless it was a matter which was instituted before the land court came into being.
No. It was filed after the specialized courts had come into existence. So the question that I'm asking you, is it odd, is it strange, is it abnormal that a judge of the Environment and Land Court is making a determination that on the face of it is a succession matter?
I think the jurisdiction of the land court, as established in the Act, is specifically to deal with the land and use. A succession matter such as inheritance would not fall within the jurisdiction of the land court.
So what would you say about this determination that has been made by this judge? Is it that he did it without jurisdiction, or he had jurisdiction?
He had no jurisdiction, my lady.
Thank you, but that's something again that you will need to look at. Thank you,
you.
Honorable CJ.
Good morning again.
Good morning, my lady.
Yes. I want to ask you about your knowledge in land law. Is there any case that comes to mind of the Supreme Court that has dealt with lease extensions and legitimate expectation that you are aware of? Would you tell us about it?
Thank you, my lady, for this question. I recall the case of Tarabana, and this involved a case where the registered owner had made an application for an extension of lease to the Commission of Lands. And before the issuance of the new title or the extended lease, another title was issued in favor of someone else. So in that case, the issue of legitimate expectation was addressed, and the Supreme Court held that where a person had land and had put in buildings, there was a legitimate expectation that the commissioner would renew their lease to the land.
Is there a difference between extension of lease and renewal of lease?
Renewal of lease presupposes a situation where the term held by a person is about to expire or has expired. And
the difference between the two?
There's a difference.
Oh, there's the difference.
Yes.
Okay. And now I want you to imagine that the President of the Republic of Kenya wishes to expand the borders of Kenya into Uganda. What process must the President follow in order to fulfill that desire? What legal process?
Thank you, my lady. With that hypothetical situation, I believe the Constitution defines the territory of Kenya, including international waters. So the question of extending the territories will probably not arise in the definition of the territory of Kenya in the Constitution.
But he wants to expand it. How, by which process can he do that? He can do it, but by which process? Which constitutional process can he expand or touch on the territory of Kenya?
My lady, I don't think the president has such powers to do so under the Constitution.
Okay, well, the Constitution defines the territories, so the Constitution can be amended.
Yes, unless probably there is an amendment either by a popular initiative or a referendum to change the Constitution to give the president such powers.
Okay, so can the president initiate a popular initiative?
No, in the BBI case, the Supreme Court held itself that the president has no powers to initiate a popular initiative.
So by what means, how else then can the president make this his intention or his wish? Is there another process he can follow?
The other process that would follow to amend the Constitution is through a referendum, which is a popular initiative by the public.
Okay, thank you very much.
Thank you.
Thank you, Chair. Good morning once again, Council.
Good morning.
I hope you're well.
I'm well, thank you.
If you need water, you can take some. You can take a pause, but if you're okay, I can proceed. We've gone through your sample writings, and you submitted to us competition tribunal judgments and a book article on international asset tracing. They demonstrate precise framing of issues, disciplined application of statutory and constitutional principle, coherent reasoning, and clear conclusions. They appropriately rely on precedent and comparative law and reflect a pragmatic and purposive jurisprudential approach. So good job in terms of what you have presented to us.
Thank you, Commissioner.
I'll ask you a question with regards to the Constitution. So the Maputo Protocol requires state parties to register all marriages, and Kenya ratified the protocol in 2010. The Marriage Act was enacted in 2014, and the Marriage Act requires that all marriages, including customary marriages, must be registered. If you look at Article 2(6), in terms of the place of treaties and conventions ratified in Kenya, Maputo Protocol will fall under that. And then you go to Article 45(1), it requires the state to protect families. 45(1), are you there?
I'm there.
And then lastly, 45(4), Parliament is expected to enact legislation that recognizes marriages concluded under any tradition or system of religion. That's 45(4). The current state of affairs in Kenya is that people undergo customary marriage, but they do not register that type of marriage. In fact, in some communities, including where I come from, a cow is more precious than a certificate. So people tend to hold on to tradition than what is provided in the law. And again, increasingly, we are seeing persons in this type of marriage seeking court intervention to divorce and distribution of property acquired in that relationship. What available avenues are there for persons who want to seek justice, and they are in customary marriages that are not registered.
Thank you, Commissioner. I agree that the Maputo Protocol is part of the international law which Kenya has acceded to by virtue of ratifying that treaty. So international law will become part of law. However, with the Marriage Act 2014, all marriages are required to be registered. This being the case, the former principle of presumption of marriage, the Supreme Court has ruled that it seems to be on its deathbed. Therefore, it will be imperative for such marriages to be registered. On the other hand, the Constitution also allows culture and tradition to be promoted and upheld. So we'll be balancing two competing interests. But I believe the Marriage Act, in essence, provided for registration of marriages, and any such marriages which are not registered then are not recognized, because after the enactment of the Marriage Act, a period was given for parties to comply with the Act by registering their marriages. That would be my answer.
So what will parties to this form of union do? They have lived together for 20 years or so, and to them they know they are married. They want to have the union dissolved and property distributed. Because where there is a wrong, there has to be some remedy. Which avenue will they pursue other than the Marriage Act?
They may pursue alternative avenues to resolve their disputes, which is permissible under the Constitution. Yeah.
Thank you. Thank you, Chair.
Thank you, Chair. Good morning once again.
Good morning, Commissioner.
I have gone through your CV, basically just to get information about the farm that you run, and I notice you have taken time to highlight the kind of cases that you handle, the clients you have, the value of the cases you've been representing them in, which gives me a fairly rough idea about the farm that you run. But what I'm wondering is, do you have a performance measurement system in your farm, or a performance appraisal system?
What we have in the farm basically are targets to be achieved by the lawyers. And for performance, we sign service level agreements with our clients which have parameters against which they judge the farm in terms of turnaround and expectations. And these service level agreements are what forms or informs whether the client will renew the service agreement or not.
And the targets that, I presume you have associates?
Yes, I do.
And partners?
I have 3 partners.
How many associates?
And 3 associates.
So the targets that you measure, could you just brief us what they are about? What are the parameters?
They are mostly income driven.
Okay. You set targets for yourself too?
We set targets.
For yourself? For yourself?
Yes.
Do you also set targets for yourself?
I also set targets for myself.
Yes. And do you have any evidence of what you have achieved maybe in the last year or last calendar year or financial year?
With me here? No, I don't have. I didn't carry any to the meeting, to the interview, sorry, Commissioner.
So you have nothing to demonstrate for us, at least from the law firm, that you are a performer and you've been able to achieve whatever indicators you have?
Commissioner, looking at my CV, I have demonstrated the clients that I serve, and having been in practice for close to 28 years, I believe I'm performing. Otherwise, I would have closed door a long time. I am also an employer.
We'll give you the benefit of doubt because we may also have scenarios where it's the partners that are actually carrying the farm and they're eager to let you go. Hence the present application.
As I mentioned earlier, mentorship is very close to my heart, and I have mentored my partners and my associates very well, and given them the opportunity to also shine in the farm. So I'm not a one-man show.
Okay. You work at the you were working at the Competitions Tribunal.
Yes, I was the chair for 5 years.
Were you filing your returns with DISPO while you were working at the tribunal?
Yes, I believe the secretariat was filing the returns.
Okay. Would they supply you periodically with your reports, your performance reports?
I don't have any at the moment. Yeah.
Okay. So maybe we can discuss something else. Huh? As you may be aware, having been part of the judiciary until very recently, the Court of Appeal has been struggling with a very heavy workload and fewer hands on deck. So I would want to ask, what is it that you would bring to the table in terms of improving on case clearance? Because the reason why we are recruiting now is to try and address that problem. What are you bringing to the table?
Thank you, Commissioner. The issue of backlog in this court is well known. I believe there are about 14,000 cases which require to be resolved. And I partially believe one of the reasons why we have the backlog is because of inadequate staffing in this court. And an exercise like recruitment or capacity building is one avenue that will assist the court in having sufficient manpower. There are other interventions which they are not my own, but I can build on them. The judiciary, through the STAJ, has taken a couple of initiatives to reduce backlog. And some of these are like Mahakama Popote programs, where judges in other court help in determining and clearing of cases. I believe another important aspect is the use of ICT in undertaking judicial functions, and AI to assist judges and judicial staff improve on speed of resolving disputes. Stakeholder engagements are also a very key instrument where the court, we have service weeks and rapid initiative programs, and through stakeholder engagements, these help the court to understand and improve on service delivery. The other key aspect is case management, and I believe case management greatly assists the court to improve on the backlog. In the case management, parties may come before the court before a hearing and give proposals for settlement of the dispute, and such mechanisms can help the court improve on reducing the backlog.
Okay, case management is a wide umbrella, so under that I presume you will also be exploring ADR.
Yes.
So what forms of ADR do you think would be appropriate for the Court of Appeal?
For the Court of Appeal, we have various forms of ADR. One of them would be mediation, reconciliation, arbitration. All the alternative justice systems would
be appropriate
for the Court of Appeal.
Okay, thank you, and I wish you well.
Thank you.
Thank you very much, and welcome back. Welcome again, Wakili.
Thank you, Commissioner.
What does integrity mean to you?
Thank you, Commissioner. Integrity basically means doing the right thing without being supervised or looking at somebody before you do anything. And integrity also goes to the values which somebody brings on board to uphold the Constitution and the code of conduct or ethics in performance of their duties. Integrity is also wide. It can include prudent management of resources which are placed before you. It can include hearing disputes without bias. And integrity basically means operating above board. And in cases where you may be faced with conflict of interest, you're duty bound to declare such interest. And if possible, you can recuse yourself from hearing the matter where there is any conflict that arises in a matter before a judicial officer.
Okay. Now, could you explain to us the guiding principles under Chapter 6 of the Constitution on leadership and integrity, and tell us the laws that were enacted to operationalize that chapter?
Thank you, Commissioner. Under the leadership and integrity article, there are various laws that have been enacted as a result of the promulgation of the Constitution of Kenya 2010. And one of the most recent one is Conflict of Interest Act. We have the Leadership and Integrity Act. We have amendments done to the Anti-Corruption Act to bring in certain amendments after the passing of the Conflict of Interest Act. These are what I can think of for the time being.
Okay. Now, how do you balance constitutional supremacy with parliamentary sovereignty?
With?
Parliamentary sovereignty. Constitutional supremacy with parliamentary sovereignty.
Thank you, Commissioner. I believe under Article 1 and 2, the Constitution is the supreme law of the land. So Constitution takes precedence above everything, but at the same time, parliamentary sovereignty refers to the making of laws by parliament and county government. So there are different arms of government, but interdependent. And this brings forth the philosophy of judicial restraint or judicial overreach, where each arm of government is expected to undertake their obligations without interference from each other, but interdependently.
Okay. Okay, Chair, thank you.
Honorable CJ, I have a few questions for you, Counsel. First, you're seeking to join a very collegial court. Would you tell us how you will handle situations where you disagree with your colleagues but need to maintain mutual respect and confidence?
Thank you, Commissioner. One of the ways of operating in a collegial agreement is to have fidelity to the Constitution and the law, and use of stare decisis where certain matters have been heard and determined. They do not necessarily have to bring conflict in a collegial court. And it is possible at times for the people sitting in a collegial court to have different views. I believe persuasion is very key. It is important to listen to your colleagues and understand their arguments. And above all, it is good to have teamwork so that despite differences of opinion, you can still agree on commonalities and deliver justice for the people of Kenya.
How about where you disagree and differ with the opinion of the others totally?
I believe the disagreement will be on the basis of the law. And like if you're writing a judgment and you have a dissenting opinion, then you're duty bound to put your reasons in writing and record them why you have arrived at a different decision. Ordinarily, courts are expected to be collegial and arrive at the same decision, but in certain circumstances where there are differences of legal positions, then you're expected to record them and give reasons for your departure.
Okay. In your stint at the tribunal, give us one innovation that you came up with and that you are able to see to fruition.
Thank you very much, Commissioner. At the tribunal, owing to the nature of competition law cases, our premises or our courtroom was underutilized. And long before the judiciary implemented shared services facilities, I was able to call the chairman of the tax tribunal, who sit almost on a daily basis, and invited them to be using our premises. And that was one area of prudent use of resources which have been put across or shared leadership. I was very glad when the Chief Justice implemented shared service facilities in Nairobi and Kisumu, because resources are few and we must use innovation to work within what is within our means.
Okay.
Thank you.
Finally, for me, please tell us of a mistake you made in your many years of practice that, given an opportunity, you'd want to go back and change, and perhaps any lessons you learned.
I would not look at any mistakes. I have, over the years, tried to be very professional in what I do. But a point in time is when I delegated certain work to one of my juniors, and the work was not done well. And it gave me an understanding that when people come to you, they come to you because they know you're capable. And it also taught me to be having a hands-on approach to such issues.
Okay. Thank you.
Thank you, Commissioner.
Yes, good morning once again, Council.
Thank you, Vice Commissioner.
Yes.
Vice Chair.
Yes. Yeah, certainly not Vice Commissioner.
Sorry about that.
Yeah, now.
Vice Chair, my apologies.
No problem. How do you balance independence of thought with collegial decision making? Of course, you're already aware that the Court of Appeal is collegial and there is independence of thought.
Yes, my thoughts to this would be to always stick to the collegial nature of this court and put aside personal thoughts, biases, which may interfere with collegial making decision. So it calls for need to put apart self-thoughts over collegial sittings.
But you are still yourself. I thought you would go there as yourself. You still have to think. If you put aside your thoughts, what would happen?
Yes, the thoughts are there, but they must be based within the parameters of the law, such that you don't bring thoughts which would otherwise not be within the law while making a judicial decision. We all have our thoughts, leanings, and biases, but I believe all thoughts must be within legal parameters while sitting in a collegial court.
Your views, where would you put them?
I believe you asked me about my legal views when it comes to working as a judicial officer.
Where would be the position of your views and all that?
My views basically would form the basis of my work, but what I'm trying to say is that you need to put a distinction between personal biases and operate within the parameters of the law.
Okay, thank you. Thank you, CJ.
Thank you very much. I think that was quite an engagement. This brings us to the end of the interview. All the questions I wanted to ask myself have been covered. But before we release you, Mr. Ogola, we always give the floor to the candidate also to engage us. So this is your time.
Thank you, Madam CJ, and to all commissioners. I wish to thank you very much for giving me this opportunity to appear before you for an interview. I don't take it for granted that amongst the applicants, this commission found fit to shortlist me to attend this interview. I am very grateful, and I wish you all the best as you sit to decide the next team of judicial officers to give this country. Secondly, Madam CJ, please allow me to pass my personal condolences to the Commission for the sad loss of our brother and friend, Justice Ibrahim. He was one of my mentors. I knew him when I was still at the university, and we continued to engage even in practice. My sincere condolences to the Commission, and I wish you well. Thank you very much.
Thank you very much for those kind words of condolences. We accept them. We will get in touch with you when we complete the exercise. For the time being, on behalf of the Commission, I wish you all the best and continue urging you to keep up the good work, whatever you are doing for Kenyans. Thank you very much also for the work you did at the Competitions Tribunal. I think we have not done a party to celebrate you, but perhaps one day we will.
Thank you, Commissioner. We actually, Madam CJ, we actually had lunch. We were about 7 chairs who were exiting.
Yes.
And we are grateful to the Office of the Registrar of Tribunals who arranged lunch for us.
Wonderful.
We are grateful.
Wonderful. Yes, at least.
Thank you very much.
We are
Madam
grateful
CJ
for that service
Commissioners.
also. Yes.
I appreciate.
All the best. Have a very good day. You are now released.
Thank you.
Yeah.